Dear participants to this lunch webinar, a very warm welcome. As president of the European Law Institute, it is a great pleasure and my privilege to welcome you all to this project kickoff webinar dedicated to the ELI project on advanced choices for future disablement in context. You may wonder why we want to have a webinar as a kickoff of a project. The idea is simple. The European Law Institute has what is called membership consultative committees, MCCs. On each project, any interested member can join this MCC and get a better understanding of the project, react to some draft at various stages, and hand in personal understanding of views on the subject. And so we thought it might be good to be as critical, as tricky at the beginning already, so that especially the two co-reporters might get as much as possible on board at the start of the project, but also you get better knowledge of the project to join then the MCC of this project by writing, and that's the easiest, by writing to the Secretariat of the European Law Institute. Now, in December 2022, the ELI Council adopted the ELI project on advanced choices for future disablement, under which the idea is to draft model laws for advanced choices with appropriate supporting material. As we will certainly hear in detail, advanced choices enable people to give instructions, record preferences, and express wishes in advance of a time when they may be disabled from doing so. The project team therefore seeks to respond to calls, including by the Council of Europe, on the need for the regulation of so-called anticipatory arrangements for subsequent incapacity. Our two project co-reporters, Professor Christiana Fontoullakis and Adrian Ward, have prepared an excellent project proposal and truly they are waiting in the starting block for this project. In fact, they are not waiting, they already began to work on this project. I'm therefore thrilled to hear what they have to say today, together with the other excellent panelists that I will have the pleasure to present to you later on. Christiana Fontoullakis is full professor of private law at the University of Fribourg in Switzerland, member of the ELI Council, and a member of the Swiss Research Council. She specializes in private law, private international law, international civil procedure, and comparative law. And among other topics, she has a particular focus on adult protection law, both from a substantive and a choice of law perspective, and has published and advised extensively in this field. Adrian D. Ward is the other project co-reporter of this ELI project. He has a long international record as expert and campaigner in law, rights policy, and practice relating to people with psychosocial, intellectual, and cognitive disabilities, and in creating service delivery projects for them. He has been published in many countries and many languages as well for almost 4 decades. But before handing them the floor, let me remind you that the chat function has been disabled, but you can and shall bring to our attention all your questions through the Q&A function. Do not hesitate, even if you have tricky questions, really, to bring them to the co-reporters' attention. And please do not wait until the end to pose your question. We will register them, and at the end, during the Q&A session, we will get through them. Now, let's start with our two co-reporters, Christiana and Adrian. You have now the floor.
Thank you very much, Pascal. Thank you not only for introducing us, but for agreeing to chair this webinar, and for, under your leadership as president, a meeting which I don't know what happened because I was put into the waiting room. ELI Council approved our project proposal and did so, as I understand it, without any dissent, which is really splendid because it's was an act of faith in us taking a rather different direction from some of the work that the council, that ELI has done. We believe there's value, but we're here to try and convince you. And if you can please be, if you can be the most critical audience we address, then perhaps it will be a little bit easier into the future. If you said it was an excellent project proposal, the credit for that goes very largely to the in-house team at ELI. I'd just like to thank them. I would like to thank everybody participating in the various roles, advisory committee, country contributors, and those who are now in the process of joining the members consultative committee. It was a great pleasure that when I started recruiting people, I just thought, who would be the very best person for this and for that? And everybody said yes, which is, we're hugely grateful to them. I would like to thank those of you attending this webinar. As I say, we look forward to our thoughts so far being stress tested. Nothing is set in stone, so we can think about what you may say and let it shape what we do. Finally, a quick word of thanks to Richard. He actually got me involved, Richard Frimston, he got me involved in ELI work. We'd done things together before that, just as one of the advisory committee on a project that he co-led in this field, and that has carried through to where we are now. Right, with that preliminary, I'm just going to start, because we are having to watch the time all the way, with a bit of role play, a case history put together from my many years as a practicing lawyer, things people wanted to provide for, if in future they might have to leave their present home and go into some form of care. Now, I, from now on, is the role play, not me personally. I'm quite elderly, still very able, physically and mentally. I've got an older sister who holds power of attorney, and I trust her, she's sensible. I've got a brother who's a bit wayward and a bit unreliable and a bit pushy, so I don't let him influence me too much. Let's assume I'm going into the care home in a week's time. I've had a physical injury and I'm not going to be able to continue here. What would I want to decide for myself? Well, where I go, which care home, take me to a few. My community is round about me and I'm well settled here, but my nearest family, my sister and her family, are at a distance. So do I want to be close to family? Do I want to be somewhere in this local community? I know one or two places I quite like. I know one or two places I've visited that I would not want to go to, and I'd want everybody to understand that. I like to see, this is one client of mine was very insistent about this, wherever you put me, even if it's not the best of rooms, put me in a room with a view of the countryside from it, particularly if I'm not going to be mobile. What about personal items? Everything in my house has to be condensed to what can come with me to my room in this care home. So what do I want to have by me? What can be disposed of? What can just be given away to charity? What would I like to go to family? Ah, I remember now, in my will, I've left certain items to certain people. Well, if they can't stay with me, I would like them to be given. Now you may say, but all of this could be decided for me by my sister. But supposing my sister doesn't survive me, I've told you she's older. Supposing at some point during my stay in this care home, she becomes unable to act or dies. And there's nobody else I would want to appoint as an attorney, but these are my wishes and in some matters my decisions. I want them to be respected. But better make sure everybody understands, in case I lose my capabilities, the medication I take, the amount of variation I'm permitted by my doctor, the allergies I have, the food likes and dislikes I have, and so forth. I don't want to find that when I'm not really able to make decisions about it, people keep giving me coffee when I'd sooner have tea, or the other way around. And visitors, importantly. There are some people, if they turn up, I would really want to see them. But if that pushy brother turns up, put him at the end of the queue, because he'll try and run everything. So here's a list of people I would, in a rough order, my preference is to make sure they can visit me if they want to. And a few, well, if they insist on visiting me, let them, but don't let them exclude anybody else. Now I'm deciding that for next week, but supposing there's no immediate prospect of that happening, but I know one day there's a probability, I will have to decide these things. And perhaps by then, I'm already no longer capable of telling people things and deciding these things. And remembering, it's fine for my sister as attorney to know about it, but by then she could be dead. So, Christiana, what can I do about that?
Thank you, Adrian. Well, what you can do in this case is to put everything down on a piece of paper and have what we would call advanced directives. In fact, what Adrian presents us here is what he presented to me maybe 1.5 years ago, and it immediately struck me as the most genial idea one could have in this domain, because obviously many countries by now have these solutions with lasting powers of attorney. But what we don't have, and I think this is really something which is absolutely crucial in the modern world where we live, and where adult protection is centered around the autonomy of the person, to have the possibility to provide for something which will be respected by any person concerned. So by the care home, by the people working there, by the family, by what you didn't mention, Adrian, are financial matters. So by my bank. So I think the possibility to decide here and now, at the moment where I am capable of making decisions, what shall happen with myself, with the visitors, with the objects that belong to me, with medication, with my pet. Well, all these things can be decided right in here, and will be binding on the person that is confronted with the question. So in medical care, it will be the hospital. In financial matters, it will be the person who will take care of my patrimony. Well, and this is actually, I think, a fantastic way to anticipate actually decisions that I cannot take, I might not be able to take at a later stage. So it's what we have called advanced directives. There are other possibilities to name it, and we'll come back to that question. But this is what this project is about. Should we give this possibility in the European territory? How could this happen? Is there a form to be respected? How old must a person be in order to be able to give advanced directives? Should they always be binding? So that's actually the idea behind this project. Adrian, I give you back the floor.
Thank you, Christiana. And you've picked up already, I gave you a scenario, and this is the way we work. She added a few bits to it. Another bit to that scenario could be, what's to happen to my house? Just sell it? Well, perhaps I would like a particular favored person to have first choice to buy it. There you have another, you can go on inventing the complications as far as you like. So I'll just pick up a couple of the slides, I think, just to follow up on what Christiana was said. If we could have slide 2, please, Katja. Some of you may be familiar with that. Those are direct quotations from Council of Europe Recommendation 2009-11, which it provided for both powers of attorney, and they have developed rapidly, but also for advanced directives with a definition and then a follow-up. And I had the interesting task of a consultancy for Council of Europe to see about a decade after that recommendation how well it was being implemented. Powers of attorney were developing rapidly over those years. Advanced directives were not. At most, we seem to have a few very limited ones for healthcare matters, or even more limited for mental health matters. So we start with that definition, but then we think about the UN Convention. If we can have slide 3, please, Katja. It also refers to preferences, will and preferences. So we've teased out 3 levels. Instructions given, I want this to happen. Preferences, and preferences is in the plural in the UN Convention. And typically, if something has to be decided, we have various preferences about it, and often they're not all compatible. So we have to make a balanced decision. And wishes made, things that now there's a gradation there from things that we'd really like to be binding to things we want to just be taken into account. So what are the issues? The biggest issue, or one of the very major issues, is that I presented you, first of all, with a scenario where I decide for something that's going to happen next week. But if I write the document that Christiana recommends, I don't know when it's going to come into operation. And it is predicated on me not being able to make my decisions then. So it could be in a few weeks, a few months, a few years. And as I characterize it, this document goes into a tunnel. I execute it, and it goes into that tunnel, and it pops out at some time in the future, which I can't predict, and people are expected to respect it. But of course, while it's down in that tunnel, it doesn't know what's happening in the world, or even to me above that. So how do we bridge that? And our preliminary conclusions are as follows. If we look at that gradation of instructions given, etc., perhaps the formalities at the outset and the security at the outset should be stricter for at least those elements. And perhaps there should be fairly strong presumptions against disapplying what I've said, with a greater degree of flexibility. So how do we create that flexibility? When we get down to preferences and wishes, any document, any record of what I wanted at one time in the past is relevant and helpful and may help people making decisions. So there is a variation there. But there could be issues, as I say, while it's in the tunnel. It might be helpful if whoever's preparing the document for me, as a matter of good practice, says, well, I'm a notary, I'll put it in my register, or it will go perhaps to a public register. Write me a letter every year to confirm you've reviewed it and that it still holds good. That will be helpful. But these are all things, even the questions that we're asking. Now, if you could go to the next slide, please, Katja. This is one of 3 slides which lists some of the issues that at an early stage we thought would require to be addressed. I'm pleased to say that even before we went to ELI Council with our proposal, we had the opportunity to discuss with such as of the participants as were on board at that stage, which let us go through some of these thoughts. This is an earlier list. The list has grown since this version, and perhaps it will grow again in view of your input. So if we go to the second one, first of all, in that list? Should there be specified exclusions? We're going to have to do a balance in model laws between things we suggest should be generally applicable across our continent with all its rich diversity of legal systems and social systems and so on, and some things where just there will have to be a prompt. If you want to exclude something from the possibility in your jurisdiction, say so here. If we go down to the second and third up from the bottom, I'm not going to talk through all of them. The clock is ticking away. Question of formalities, I've touched on that. What should happen if the formalities are not complied with? If I give all sorts of instructions, but I've just scribbled it down and nobody, if I'm in a jurisdiction where notaries have a significant role, nobody's notarized it, no evidence anybody's advised me about it, well, it would still drop down to that lower category of my preferences and my wishes, but the possibility of departing from it might be greater. Next slide, please, Katja. The second one from the bottom in this list is significant, this question of disapplication. And we envisage at this stage that we will have criteria so that at what we would call the top level, it's been done before a notary or by an equivalent procedure. If we have expressed wishes about future medical treatment, we record in the document that we have discussed that with a medical practitioner, and various other features, which is linked to the bottom one. When is it legitimate to act, and when it is legitimate to act on it, even if I'm saying otherwise? Now, here we come to this concept of will and preferences. If I've got a disorder which causes me to jump all over the place in my decision making, when I say no or yes to something today, that may not be the same answer as next week. So it does take people who know me, hopefully the kindly and helpful care home staffers, apart from anything else. Oh yes, about once a week he has a day when he wants to leave here and he wants to get out of here, and the rest of the time he's happy. So we can't get away from the need to make judgments. If we come to the next slide, Katja, this is the last one I shall speak to. First one there, that's where a flavor of private international law comes in, but this is not a private international law project, but a degree of similarity where, as we all know, Europe will tend country by country to go off in different directions, could be helpful. At least somebody, if my document has to be produced in another country, if it's something that people there can recognize as to what it is, and they have a regime which takes account of these things turning up from somewhere else, that could be helpful. But as I stress, it is not a private international law project, but we do have this window of opportunity because my work for Council of Europe told me that this is an undeveloped concept anywhere. So if, in effect, we in ELI can get in first and put thoughts in people's minds, it may stimulate them to do it, which has not happened to any great extent, but not to be different just for the sake of being different. There may be good reasons to be different. And the last one there, which is where I will finish, I've mentioned already to the UN Convention, that really brings together, as Christiana mentioned, first of all, the Council of Europe concept of the importance of autonomy and self-determination, and secondly, the Disability Convention concept of the importance of your rights, your will, and your preferences. So obviously, the obvious one is the safeguards at the time of granting, and the other safeguards in the convention. So I'm going to hand back to Christiana, just to tell you a little bit. I've told you what the challenges are and a little flavor of what we need to do. Christiana will tell you a little with the last two slides, how we're setting about it and with whom. So back to you, Christiana.
Thank you very much, Adrian. So here you see the participants of the project, the reporters, so actually the persons who will write up the model laws, and the supportive material will be Adrian and I, but we will heavily rely on numerous people who all are first choices, as Adrian said it. So we are very, very lucky to have many experts from many countries within Europe. I will not go through all the names. They are in alphabetical order, but you have them here on the slide. The advisors are persons, so specialists, who will tackle topics that are not really just a report of the situation in a country. It's more on interdisciplinary aspects that we ask them to contribute. But some of the advisors are also country contributors, which means that we ask those specialists to explain to us what the current legal situation concerning adult protection is in their country. And for that reason, we have drafted a questionnaire which has already been distributed among the advisors and the country contributors, and where we ask many questions, which we will then work on. And actually, we will heavily rely on what will be provided as an answer by our specialists in order to then come up with a proposal for advanced directives that could be serving as a model for national legislators. Then there is the MCC. As you know, Ilaria Pritelli is the president of this MCC, and for the moment we have 5 members. So that would be an opportunity for those of you who might be interested in joining the MCC to do so after the webinar. Katja, could you show the next slide? It's the last one, actually. It shows the timetable. We started in January by drafting and finalizing the questionnaire, which is now with the reporters. We hope that all questionnaires will be returned by August this year, and will then write up a report which resumes and combines the answers given by the reporters to our questions. And then we will have the model laws finalized by May 2023. We will author them, but obviously always in very close touch with the reporters, and we will then have the supporting materials, so which will be very practical guidelines and other hopefully helpful material in order to implement those model laws in practice, ready by November 24, and will then submit to ELI, because we need the approval of the ELI in order to have our project completed. I think this is what we wanted to say. It rings 1 o'clock. I think we are in time here. Pascal, is it?
Thank you very much. I didn't know whether Adrian wanted to say a final word, that's why I waited, but thank you very much to both of you for this very interesting and complete presentation, and indeed right on time, the time allocated to you, so the timeline was also respected, so to say. So now we will continue our journey through this project, first with Ilaria Pritelli. She's a legal counsel and expert in private international law at the Swiss Institute of Comparative Law. And as you have seen, she's the MCC chair of the ELI project we are discussing here. She's also the editor of the Yearbook of Private International Law, among, of course, many other engagements she has. And her main domain of interest are the international and comparative dimension of family law, and more generally the protection of children and other vulnerable subjects by means of private international law and fundamental rights. I think I said she's a member of the ELI Council. If I did not, I say it again. So Ilaria will now bring her own perspective in that, and you have the floor, Ilaria. Thank you.
Thank you very much, Pascal, and thank you very much, Adrian and Christiane, because for your project, which is indeed excellent. And as far as I have seen up to now, and also from its really basic idea, a genial idea, as you said, Christiane. So the project is concerned with the protection of the free will of vulnerable persons, who may be incapable of expressing it at a certain moment of their life. So it covers really rules that will be capable of ensuring to the highest possible degree the exercise of party autonomy, of course, taking into account the degree of their capacity for discernment. And to this extent, this project is naturally the continuing, or it really deepens, widens, and continues other very important ELI projects in this field, as the project on, I may recall, empowering European families towards more party autonomy in European family and succession law, that was led by Katarina Belevelki, Wendy Schramme, and of course Christian Vanderhorst, who was completed in 2019. But also the other project on the protection of adults in international situations, with as co-reporters Pietro Franzina and Richard Frimston, who will follow up this small talk. And this was completed in 2020. As compared, of course, to the former, as it was already said, the present project does not have a focus on private international law, but rather on comparative law, and also with a view of elaborating a model. So uniform rules capable of being adopted by various legal orders. And indeed, we need we have common principles here, very common principles that we have to share. If I may recall, one of the expressions of the principle of free and informed consent of the patient in the administration of healthcare, if I may quote it, it is that the person, I quote, the person involved should have legal capacity to give consent, should be so situated as to be able to exercise free power of choice without the intervention of any element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion, and should have sufficient knowledge and comprehension of the elements of the subject matter involved as to enable him to make an understanding and enlightened decision. So in these words, the principle was expressed by the first principle of the Nuremberg Court in the trial proceedings of 1947. And that consent, their consent, was really conceived as an absolute prerequisite for any conduct of research involving humans after the world had come to know of the atrocities committing during that armed conflict. So I quote it because that was the real beginning of a paradigm shift, the paradigm shift already taking place and evoked here, and leading to abandon what we may call the Roman approach that was aiming at protecting property from the vulnerable adults instead of assisting the vulnerable in order to enable him or her to take decisions concerning every aspect, as has been said by Adrian, of his future life. So this legislative trend is going towards limiting as far as possible the measures that may restrict the adult's self-determination and enable him really to decide also also assist him in the decision during the time where he's capable, because the capacity is not lost immediately in a way from one day to the other. It can be so, but it can also be that it is there are moments where will can still be expressed but need some assistance. So against this background, we should also not forget that medical costs of the aging population have had a significant impact on national legislative initiatives on self-determination. This has been explicitly recognized by certain legal reformers. I may recall the Netherlands, for instance, where it was really written that one of the reasons for the Dutch reform that led to the privatization of adult care was the need to reduce public expenditure on health care. So in this regard, the ambiguity also, I want to recall the ambiguity of the principle of self-determination has been pointed out by certain literature, and calls for reflection and caution when we think about how implementing it. So this is one of the many challenges of this project that requires the highest attention of experts, such as those that will be reunited in the consultative committee, which I have the honor to chair. And this consultative committee, together with the advisors, but please, all of you that are here now in this webinar, and you think you may have a say, you may have a word, you don't need to be expert to join the consultative committee, because what we need here, it's really to fuel the discussion that will take place and that will be conducted by the reporters who have the responsibility for the project, but who may only benefit from any challenge, any critics also made prior to the completion of the project. All ELI members, irrespective of their status, and also persons who are considering to join ELI are really invited to join the consultative committee. I repeat, without the necessity to be expert in the relevant field, because they may also bring the focus where it is not at present. And all contributions will be acknowledged also by the final ELI output. I really wish to recall, and I will close, that the strength of ELI project is really this collegiality and the diversity of the team. So every ELI project is the fruit of an authentic collegial effort. We have seen this in previous projects, and I very much look forward for you to join the consultative committee and bring your point of view. Thank you very much for your attention.
Thank you very much, Ilaria, and thank you very much also for this call and putting, the MCC into perspective, because that helps a lot. And we will now go on with Richard Frimston. As we've heard, he has been a co-reporter of the completed ELI project on the protection of adults in international situations. He's a consultant in the private client team of Russell Cook Solicitors, and he advises clients in relation to their estate planning, wills, probate, and tax planning issues, and offers notary public services. So he's really the practitioner, and we are looking forward, so to say, to thanks to your area of expertise, also what you have to say in this regard. Richard, you have the floor.
Thank you very much, Pascal. And thank you to all of you for inviting me to take part. I think where I would like to go is just to pick up from our previous project, which was very much focused looking at the Hague Convention of 2000, and whether Europe might think about how that might be brought further into effect throughout Europe, and whether anything more needed to be done. And of course, this whole area of law is one that keeps changing, and the language that we use changes as well. Whereas the UN Convention talked about the rights of persons with disability, the Hague Convention talked about vulnerable adults. The language that we use is something that we're all very sensitive to, and that we keep changing. And here we are, we're talking about advanced choices rather than advanced directives. But the Hague Convention, obviously, its building block was a measure of protection, and a long debate about what was a measure of protection. Could a power of representation be a measure of protection? And the answer was yes, if it had been confirmed in a particular way. But many powers of representation are not measures of protection. And there's a long debate about whether an advanced choice might be a measure of protection. And again, the answer is probably not. Should it be? Should the Hague Convention be amended? Should a protocol be proposed that might include advanced choices within the ambit of the Hague Convention? We had a special commission at the end of last year, which was great to see. A lot of work done, a lot of new documents. There's now preliminary document 12 on the Hague website talking about the need for a protocol and whether advanced choices should be included in some way. But I think the fundamental problem in this area is that whereas the UN Convention has made us all think about the rights of persons and the importance of everybody making decisions as far as they can, many legal systems and our traditions still look at either somebody has legal capacity or they don't, and it's an on-off switch. And that on-off switch is still something that it's implied in the Hague Convention, even though it shouldn't be and doesn't need to be. So when does a power of representation come into force? When is it applicable? Maybe when somebody loses capacity. But have they only lost capacity in certain areas and not others? How much should we look at an advanced choice and say the person who's made it still has capacity to make decisions on some of these issues, but not others? They've changed their mind on some issues. How much should we take that into account or not take it into account? The Hague Convention keeps developing. We've got Greece and Malta now have ratified. The wonderful Irish law of 2015 finally came into force last month on the 26th of April. We're hoping that Ireland will ratify the convention this year too. So Ireland has now brought into effect their Part 8 of their Act, advanced healthcare directives. So it'll be interesting to see how the law develops in Ireland. I think my concern is I share with Adrian the EU Council conclusion in 2021 on this area was that freedom of movement is currently obstructed by legal systems that stop people who don't have full capacity or ability in exercising their right of freedom of movement. And the right to self-determination is a fundamental right, the EU Council said, and a power of representation should be respected within the European Union. And I think that should obviously also apply to advanced choices. I think the Dutch model is a really good one. And even though they haven't ratified the Hague Convention, they still behave as if they have. And there you have the Dutch Levenstestament, which has become a sort of standard for Dutch people to think about, which incorporates all of these things: which incorporates the power of representation, but also advanced choices, and therefore may deal with some of the aspects of formality, and tie in the issue about when you need to look at the document, how much capacity and what capacity does somebody have. So I think this is a wonderful project, and I look forward to looking at it from the sidelines and seeing how it's coming along. We're hoping that the EU Commission will come forward with proposals this year. It'll be interesting to see what they are in relation to the Hague Convention. But I think trying to push those and think about where advanced choices may sit within the overall private international law issue is a good one. So thank you very much, and I look forward very much to seeing this project go forward. Thank you.
Thank you very much, Richard. Thank you also for stressing the whole difficulty of the coming into force of these advanced choices, especially if they are related to maybe different areas where one has the capacity on one and not on the other. And what if those two areas are correlated in the advanced choice, and one might have been dependent on the other, and then of course it creates even more complex situation. So thank you very much also for stressing the importance of the potential protocol of the HCCH, the Hague Convention, because I think that is also something to be kept in mind. With that, we have finished the first phase of our webinar, which is the various presentations, and the call is always out there. So do not hesitate to ask questions. Use the Q&A function to come with questions. I haven't seen any right now, but of course I have at least one in my sleeve already, ready for the two co-reporters, because one question I have is really the issue of enforceability of these advanced choices. We know that, for instance, in matrimonial agreements, the Americans say sometimes there are some limits. You cannot set everything in these agreements, because at the end of the day, whether one has to clean on the Friday morning and the other on the Friday afternoon or whatever, this cannot really be enforced by courts. And so when I look, Adrian, at your list of aspect, wishes, and so on, I'm just wondering, what about enforceability? Because it's nice to say, okay, put your wishes down. You have a piece of paper that is valid, that of course may suddenly get into contradiction with other fundamental rights, and some court will need to decide whether this is enforceable, or de minimis non curat praetor, or whether the judge would say, you know, this is really not normatively strong enough to ask for a decision by the court. What would you say on that?
Thank you for that point, Pascal. I did say in my presentation we had one point that wasn't in the list, and you, of course, have unerringly put your finger on it, but I did have a discussion about it with some of our participants after we started, but fortunately before we finalized this questionnaire. So it is addressed in the questionnaire, and in the questionnaire we're addressing it along the lines of what mechanisms for enforcement does your jurisdiction, is addressed to individual country contributors, does your jurisdiction have for this purpose? And one of the obvious things is that once, in my example, once my sister is no longer acting, my document is addressed to the world at large. So if the care home start doing things that some of my visitors know I didn't want, and they're upset about it, what can they do? I think we have to start by learning from analogous availabilities in existing systems. We have to be careful that that bossy brother doesn't try to dominate everything and come in and tell them what to do. And ultimately, someone has to adjudicate. It has to be a court or equivalent. That is where I think we can offer principles to guide that decision. And I gave some examples. If I have taken professional advice on what I've provided, that's rather stronger, with a stronger presumption that it should stand than if I've just made up my own mind with no evidence of doing that. But who can do it? Different legal systems have different criteria. In some cases, anybody who claims to have an interest in the matter can. In other cases, someone has to demonstrate why they are taking it upon themselves. But there would need to be this openness, just because there may not be anybody nominated. If you go back to the Council of Europe definition, which we showed earlier, the second part of that, what it might be used for, includes your choice of guardian should one be appointed. And it may be that that would reasonably be interpreted as your choice of who should not be your guardian. That's where I would exclude my bossy brother. And one route might be that a guardianship or equivalent procedure might need to be applied for and put in place for someone to demonstrate that they are an appropriate person, not to act for me as if I hadn't granted this advance document, but to act for the purpose of making sure it is respected. So that if I don't know who I wanted to appoint to that role, a court could conclude that a practicing lawyer with considerable expertise, who doesn't necessarily know me particularly well, but can read. And it's surprising how often in this field, once we move from theory to practice, people just don't read what's in front of them, can read the document and say, no, he said this. But we're open on that. This is part of the reason, if we knew all the answers, we wouldn't have the project. And we need people like you and your perceptive own question to help us shape it.
Thank you very much. And of course, not every decision has to come to the end in front of court. And so, of course, there's a lot to be done before, also in terms of soft approaches and so on.
If I could follow up on that comment, Pascal.
Yes, please. Yeah.
My experience as a practicing lawyer is that if in any situation there is a clear mechanism to resolve a dispute, you get fewer disputes, because people's minds are focused not just, I want this, I think that, but, oh, how would the judge or whoever it is look at what I'm saying? So the fact of having the mechanism helps, even though we have a classic case in Scotland with our incapacity legislation, and our parliament had spent a lot of time worrying about a particular clash that could occur. In that case, it was between an attorney or guardian on the one hand and a doctor. And we devised a mechanism. And some years later, I said to the people in charge of that mechanism, how often have you operated it? And they said, well, we've had 4 applications, but they were all resolved without having to go through the procedure.
Yeah, sure. Thank you. And maybe in line with this non-conflictual or non-judiciary perspective, and I will come back also to recognition, a lot of this is linked to a unilateral decision process by the person affected or potentially affected by some disabilities later on. And the question which has been posed in the Q&A by the president of the European Land Registry is, but how can we know whether or not such an agreement is enforced? You mentioned the timeline, of course, and the difficulty. And so I was wondering, Christiana, to whether you have an idea, because she suggests maybe there should be a kind of European registry of such instruments, so that it would be possible to identify at what time the enforceability, the validity takes effect. But of course, that might be tricky, because they might also, as Richard mentioned, take only partly effect or not at all at some point. So I don't know whether you want to react, Christiana, on this registry issue.
Yeah, that's one of the questions that we have put on our agenda. So Adrian will maybe have another view, or maybe just might want to add something, but we put it in our response to the EU Commission, but actually the EU Commission asked for reactions as to their question whether there should be a proposal regarding international private law in adult protection. And we suggested that there should be something like a European registry where measures and I would say also advanced directives should be registered so that everyone on European territory knows that they have been authored. Now, how exactly this could work, I think that there is something similar in succession law. Richard, you will correct me, I didn't really look it up, but I think there's something similar. The idea could be that with advanced directives, which can to a certain extent be compared to a will, but obviously the person is still alive, but still might not be able to react any longer, could thus follow the same path actually that was taken in European international private law regarding successions. And the second question, how do we know, I mean, how should this work, and should advanced directives only apply once the person is incapable or not? That's another question that we want to tackle and where we don't have clear answers, but I would well, if I draw from Swiss law, we have this notion regarding incapacity, which is what we call a relative notion. So it's possible that a person is no longer capable of taking decisions, let's say in patrimonial matters, but still able to decide on healthcare matters. And that might be an approach. So it's not the on and off switch that was mentioned, but to say that it could be a gradual entry into force of those advanced directives.
Thank you very much, but that might exactly be the point of the problem, and I will ask Richard to react on that. When you have one single document with different level of wishes, decisions in anticipation and so on, that require different level of capacity, so that capacity might be given in some places and some others. And if I do understand the question by Louisa Claude, the president of the European Land Registry Association, it is also to say that if we have the registration of such document in a European registry, how will we know that this is in force or not, given that contrary to death, it's not just you are dead or you're alive, but you might be capable on some aspects, not on some others, and this also is a matter of assessment. Richard, do you want to answer?
I agree,
and
I think that's one of the problems with the UN Convention, which is such a wonderful convention, and we all agree with it, don't we? But if you're a bank and you're presented with a document, you want to know, can I pay out on this document or not? Can I pay out safely? And that's one of the problems, is if we're in an area of complexity, how do you provide simple solutions? And that's where it's so difficult. I mean, I think the other issue that I would pick up on is Christiana talked about the European equivalent in relation to wills and succession. We got very much the same issue in that everybody's cultural background is different. Some countries like central registers, some countries don't like central registers at all. And trying to mesh those in is really quite difficult. I think the other fundamental area of difficulty in Europe is the idea of end-of-life decisions. One of the few areas in England and Wales wherein the standard lasting power of attorney for healthcare decisions, as the person making the document, you have to decide, do I want my attorney to be able to make end-of-life decisions or not? And we had thought that one of the problems in relation to the Hague Convention was the fact that culturally some countries don't like the idea of end-of-life decisions. And then we were surprised when Spain came along and introduced assisted dying, when we thought culturally that was difficult. Whereas maybe, I don't know, without quoting particular Eastern European countries, with different cultural backgrounds, they might find end-of-life decisions very difficult. So again, public policy issues in relation to advanced choices are also difficult and not uniform throughout Europe.
Thank you very much. Yeah, I see this point. I see, Adrian, you want to react, right?
I'll just elaborate a little on that ELI response to the EU last year that Christiana mentioned. That's when Christiana and I first met, actually, and we had 5 points, I think, in that, and there were 5 of us on that little working group, which was quite helpful. We mentioned the possibility of what we now call advanced choices, and we mentioned the possibility of a central register against a background where, to my knowledge, in more than one European country, people responsible for registers that already exist, such as registers of powers of attorney, are looking at taking advantages of technology to be able to tell someone very quickly if a doctor is in touch, this patient from X country has arrived at my hospital in Y country, who is entitled to make decisions, because right now they can't, to be able electronically to access what document exists and whether it's still in force. And the people I talk to who have practical experience of registering and overseeing, they will tell you one of their big problems is that we have the attorney who has misbehaved and he's been removed from his appointment. And he goes round the banks producing this document, which a court revoked yesterday or the day before, and he draws money and disappears. Now that does happen. So the proposal was that basic facts should be updated with this register in real time. For states that participate, if they're contemplating such a system anyway, they're going to have the cost of doing it. And it may well be that ultimately, in cost terms, a single European register to which they subscribe will in fact save costs. It'll save costs with registrars speaking through central authorities who speak to each other, and people have to spend professional time deciding what's what in a particular situation. So there could be general advantages. And because I was the voice from this little island, which has not yet completely crossed the Atlantic, though it's been sailing away a little bit, let other states, if that's to be a European Union system, there seems to me to be no reason why other states should not be able to opt in and join in. So that's what we said there. And yes, that along with advanced choices were 2 of our ideas. They weren't linked, but the link is fairly obvious. The other way is for states individually to have the same and a way of ascertaining, does such a document exist? How can it be updated? And where associations of notaries, for example, are very strong and they have their own register, you don't reinvent something that exists, but they might want to tie in with such a system as well.
Yeah, thank you very much. And what you underline about the updating is, of course, also related to one of the other questions we have in the Q&A, and of course, do not hesitate to ask further questions, which is about recognition of decisions, because it's one point to have a decision, for instance, removing the power of attorney of someone, of your older sister or your brother, as in your example. But then this decision needs to be recognized, needs to be on the registry, and then there is not only the recognition, of course, of the decision as such, but also of these these agreements and these documents, these advanced choices. So I was wondering to give the floor to Ilaria, and then I might come back to Christiana. Ilaria, do you think it's feasible? Because I know you do a lot in private international, and you have been active also within the HCCH. Can it work?
So yes, thank you very much, Pascal, for giving me the floor again on this topic. So can it work? Of course, it depends on the situation. Here, this is a field where it is very important to give enough. Always to bear in mind that the rules give enough space for discretionary choices, because things may change. And this also was the background where that led, for instance, Italy. I have, of course, the example of Italy in 2004, where they introduced as what they call administration to support, or supportive administration, which was a way to not really to allow advanced choices, but to accompany the choices of vulnerable adults. And so I think that the issue is this interplay between evaluating the situation at a given moment, assessing which incapacities are hindering the person from expressing a will, and then enabling another person, or making the advanced choices have a role. And I would like to turn your question also to another, to the other panelists, by especially Christiana and Adrian, to assess whether you have considered, for example, what it is when it comes to the right to vote. I have these persons, how can they exercise a right to vote? Can this be included in the advanced choices? Can this be part of advanced choices, or how can we accompany an adult? And how many legislation just make it automatical, have this automaticity that when you lose part of your abilities, then you automatically lose your right to vote. Thank you.
Thank you very much. Christiana, you want to react? Being in Switzerland,
yes.
where we vote all the time.
Yes, very quickly, and Adrian, obviously then you'll have the floor, but just in order to answer to the second question, the right to vote, I mean, at least in Swiss law understanding, this would be a question of public law. And here, if you are under guardianship, you lose the right to vote. But if you're just incapable, I think there is no specific legislation. You just don't vote. That's the idea, probably, because you can't. But I can't imagine that there is here some system of representation that you could use. But yeah, it's something to be explored. My other point was, because the question that was raised, how do you recognize those advanced choices, and when should they, from what time on should they be entered into force? But I think maybe the problem is not that big as such, because I mean, advanced choices are actually choices that you make today, but and which should then count once you can no longer express them. But actually, if they asked you today what you want to do in hospital, or what happens to your flowers and to your goods, you would give probably the same answer that you write down in the advanced directives. It's not the question of having a person who will act on my behalf. It's actually, I am saying what I want to do, and I could say so today, where I'm capable of. I could, and if what I say today, which if you ask me directly, will be the same that I put down on the advanced directives. So what I want to say by that is, it's it's anyway, I have already decided what I want to do, and I don't really see the point of the enforcement of the advanced directives, because it's actually, the answer has been given. The answer would be the same if I answered it directly today, obviously. You know what I mean? It's not me being no longer asked and then someone else answers on my behalf. It's I have already answered the question.
I see. Thank you. So you have already an answer, but of course these surrounding circumstances may have changed. And so the question might be, do you still stick to your answer, given that the surrounding circumstances have changed, that the, I don't know, other fundamental rights might be also playing a more important role now than it was when you drafted your advanced choices? Because as was mentioned by Ilaria, autonomy of will is central, and therefore, of course, this is a fundamental right, but at the same time, you may have other fundamental right conflicting and being more important later on in time, and that might be a difficulty, I would say. I see that. Adrian, you wanted to react as well, I think.
I think I'm being invited to anyway, so yeah. Let's start with a basic concept that we lawyers tend to divide the law into topics, and we sort of put them in vertical boxes, if you might say. We have, I mean, tax law is rather different from property law, but it can interrelate. All the different legal subjects, criminal law and all the rest of it. I always characterize issues of capacity and capability as a horizontal seam that runs across all these boxes and can interrelate with any area of law. And certainly in the systems with which I am familiar, there are awkwardnesses at that point. And getting back to the original question, voting. Now, in this country, our Parliament moved towards a more liberal approach, more facilitative, and why shouldn't people be able to vote? But then we discovered that the guidance in the registration system, the system of registering to vote, still presented significant obstructions in actually registering. And if you haven't registered to vote, I live in this place and should be able to vote within that area, you've still got a problem. This is a constant issue. We will not solve all the problems of the world. In this matter, I feel this is probably one that goes rather towards the asking legislatures to consider if there is something they want to exclude. Right to vote, right to marry. But we have to be very careful, and this is a big issue in this whole subject. Just because of a diagnosis or putting somebody in a category does not mean that they are not capable of something. People with severe mental health issues can nevertheless competently decide some things. People with other conditions can still decide something. My personal view is that, I'm thinking again of the advanced choice, if the person wants to be able to vote and can get as far as, I want to go and vote, I know there's an election on, I see no reason why they should be stopped. For many decisions in life with fully capable people, we don't monitor whether the decision was sensible or not. Why should we monitor? And people will vote for things that I might say, well, I don't see how any sensible person would vote for that. But sometimes even a majority in one's own country does, not thinking of anything in particular. So I think what I like to say sometimes is that law in this area can provide a useful framework for getting individual decisions right. It can't make the decisions for you. And unfortunately, it can provide a framework within which you can get things wrong. On the question of, I mean, as lawyers, we talk about recognition and enforcement. all my years in practice, what really mattered to people was what I call operability. If I produce this document at the front desk of a bank, or if I quote it to a call center for that financial institution, or if I produce it to a healthcare frontline worker, am I going to have unnecessary difficulty? And the experience of people, I'm afraid, with things like powers of attorney, often is that they do. So there's a major issue there we have to keep working with. And this comes down to, I always say, legislation in any of these areas is about half the job done, and the other half is the dissemination and getting public awareness and professional awareness. But we can't dodge the issue. And as I say, my specific answer on voting is probably it's ultimately for each legislature to decide what is excluded.
Oh, thank you very much. And indeed, that would be public and mandatory law, so that it will preempt probably on these choices. I have a question to Richard, because we have a question in the Q&A section on what happens if Adrian's sister, who was appointed in your hypothetical as having the power of attorney, wants to do something different from the decision that are included in the advanced choice document. So the same person giving once a general power to someone to decide, but deciding at the same time himself or herself in a different way than the one who is supposed to take care does it. So how would you resolve that from a practical point of view, or maybe a dogmatical point of view? I don't want to limit you to the practical side, of course.
Well, again, I think it depends on, if Adrian still has capacity, then the attorney, the donor of the power of attorney, shouldn't be acting anyway. So the question will be, does Adrian have capacity on this particular issue? If he doesn't, then the donee of the power of attorney should be taking into account all of Adrian's wishes and operating as best they can for whether it's his best interest or what he wants. The question is, what if you have an attorney who's nasty and doesn't do the right thing? Who steps in and controls the attorney? Well, that's true whether there's an advanced choice or not. Who is overseeing the attorney? Is somebody else around to complain and say the attorney shouldn't be doing that? As Adrian says, these things are about operability and in practice, whether somebody is looking over the shoulder of the attorney or not.
Yeah, indeed. And at the end of the day, maybe even liability for the one having power of attorney, not taking into account the advanced choices that indeed are here for, helping him, directing him. Indeed. Thank you very much. Christiana or Adrian, I think because the time is going forward, maybe I would give you the floor for a last couple of comments if you want to. And then I will wrap up the session. Who wants to begin? Maybe Christiana?
I'll start, I think.
Sorry.
Yeah, okay. I think this was extremely helpful for us. So thank you very, very much for being here and for asking your questions, giving your comments on that. This is work in progress. So I've noted everything that has been asked. Obviously, we don't have precise answers at the moment, but this is exactly what that's the aim, to come up with proposals that are realistic and practical and operable, as Adrian has mentioned it. So thank you very, very much for your input, and I hope that the one or the other person has now decided to join the consultative committee.
Thank you very much, Adrian.
I would just echo what Christiana has said. This has been hugely helpful, but I guess it's only a small sample of a flavor of what those who accept Ilaria's invitation to join the members' consultative committee. And it follows from what I said a little bit, that we're talking about a topic which interfaces with every type of law. And it may well be, they always say that the spectator at the back of the stand sometimes sees something that people on the field of play have not noticed. Someone commenting from a distance in legal terms may well have something in particular that is useful for us. So what I would say is that if the discussion that you have chaired for us, Pascal, stimulates people to have further thoughts, please bring them to the MCC and we will get them from there. I can't think that any comment at all will not have value, because of the mere fact it has occurred to someone somewhere means that it has that value. So I would just say my thanks to everybody who's participated in this session, and above all to you, Pascal, for chairing it for us so expertly.
Thank you very much. This is too kind. I want also to, at the end of this kickoff seminar, to make two remarks. One is that I think it reveals to be very interesting to have a kickoff webinar to stimulate ideas and questions. And that, of course, it's easier when you know all the answers, because that's at the end of the project. But at the same time, you cannot benefit from all the questions unless you have already anticipated all the questions, and one knows that this is impossible. So I think we will repeat this type of kickoff seminars, webinars with other projects. The second is this kickoff webinar has been recorded. It will be on our channels, regular channel, also on the web page. So if someone watched this recording and thinks of, questions and issues he or she wants to communicate, it's never too late. And I wanted to say, even in 3 years from now, if you are watching this video, who knows, you might still send a message to secretariat@europeanlawinstitute.eu and see whether, it's time for a protocol, for an addition, or for different perspectives. At least do not hesitate to do it anytime, because also during the process. If you are not member of the MCC, you can still become one at any point, so do that. But if you are not and do not want to, you still are allowed, of course, to send questions to the secretariat, which will then forward it to the two reporters. It is then finally my duty and my pleasure to thank all the panelists, because I think they really also took some risks, because to be on a panel when you do not have all the answers before having the questions, it's always subject to some risks. And I think you did a marvelous job. So thank you, Richard Frimston. Thank you, Ilaria Pretelli. And of course, thank you to both of our co-reporters, Christiana Funtoulakis and Adrian Ward, for this wonderful lunch webinar, but also for taking on this very important project on behalf of the European Law Institute. The Council is really grateful to you for this project and for bringing that forward. And I have to say, I look forward to further Council meeting when you will be presenting intermediary and then final result of that work, because I am sure it will also be the opportunity to have a very nice discussion on that. With that being said, I wish you all and all the people who listened to the webinar, but also those who will listen to the recording, a wonderful afternoon, a good continuation in this week, and see you next for a further webinar, among others, the 1st of June, when we have the ELI Membership Day, where you are all highly welcome. Bye-bye. Thank you very much.